Good morning, everyone. I think the number of participants has slowly started to stop increasing. So I think most people who are planning to attend have hopefully now joined. So we will get underway. This is the latest in our series of King's Young Professional Seminar Series. My name is Aidan Reay. I practice in the business and property section of King's Chambers with a focus on corporate, commercial and insolvency disputes. And I'm going to be talking today about unfair prejudice. And the focus of my talk is going to hopefully be on giving you some practical tips for how you go about dealing with it and the key things to bear in mind when facing an unfair prejudice petition or pursuing an unfair prejudice petition. Unfair prejudice petitions then. These are governed by Section 994 of the Companies Act 2006. And I've set out in full on this slide the scope of that section and what it provides for. Probably the most important thing coming out of the legislative text itself is that you've got to always be mindful of the fact that what you are looking at is the thing that is covered in subsection 1A, which is namely that the company's affairs are being or have been conducted in a manner that is unfairly prejudicial to the interests of members generally, or of some part of its members, including at least the petitioner. When the dispute walks through your door as a litigator, the first thing obviously is who are you acting for? Are you acting for the petitioner or the respondent? If you're acting for the petitioner, as a general rule, of course, there are always exceptions to general rules, but as a general rule, you are probably in a strong position because once a dispute has kicked off, once people have fallen out, the end point is probably going to be that someone buys your client's shares. And so you have, if you like, the momentum. You have the upper hand, effectively, at starting off, assuming, of course, always that you can afford to fund the litigation. But one of the errors people can make is to be overconfident about their position as a result of that general default rule. And so there are a few things that it's important, really, just to make sure when that claim first arrives. Now, the first thing that it's important to do is actually to check that the person you're instructed by does actually own shares in the company. You're standing to present an unfair prejudice petition. It's linked to your ownership of shares in the company. And if, for example, that ownership is imminently threatened, it might be a situation in which you need to apply for urgent injunctive relief, or if something has already happened to transfer shares away from your client, it might be a situation where you're going to need to have him restored to the register before you can present an unfair prejudice petition. Now, you might do the two things from a procedural point of view, you might do the two together, but the restoration on the register will have to logically happen first before anything else happens, and so that can impact case management. When you want to check if somebody is the owner of shares in the company, in theory, the starting point should be the register of members, because under the Companies Act, companies are required ordinarily to have a register of members, and you become a member of a company by being entered into the register of members. But the number of times that the register of members simply doesn't exist would shock the average person. I regularly find in practice that certainly in small private companies, that no register of members has ever been kept. Now, this was effectively a reality that Parliament recognised and legislated to deal with. So Chapter 2A was introduced into Part 8 of the Companies Act, and that allows for private limited companies to elect to have information as to membership kept on the central, what's referred to in the chapter is the central register, and what that means is Companies House. But you have to elect to do that. And again, a lot of companies think, oh, well, with lodged confirmation statements or what have you, but they may not actually have elected to make use of the central register. So you can have this problem. Now, in practice, often a lot of the time, what's source of the goose is source of the gander. There may have been share transactions, transfers that haven't properly been recorded, and sometimes just becomes the case that it's in nobody's interest taking these points. So everybody proceeds on the basis that the current shareholding is as it was always understood to be. But it is something that you need to be mindful of, because it may well be that the relief that you require, for example, includes not simply buyout provisions or any other provisions that you're seeking, but also actually that you need some relief which reorders the shareholdings. And as I said at the outset, you've got to actually have a shareholding to have the standing to pursue your unfair prejudice petition. The other thing you need to do as a petitioner's representative is you've got to sense check the case. One of the really important things is when somebody comes to you is, does the client actually want to sell their shares? Because, of course, what's usually happened in the context of, certainly in small private limited companies, but even in larger companies, is that the personalities involved have fallen out with each other. And when you pull the trigger on the unfair prejudice petition, it's likely, and again, nothing's inevitable, but it's likely to lead to a one-way track to the shares being sold. It's probably going to end up. It's not likely to improve relations between the parties, and so it's probably likely to ultimately lead towards either by way of settlement or by way of court order, some sort of buyout happening. And of course, if that's not actually ultimately what your client wants, then it may not be in their interest to pursue an unfair prejudice petition, at least not until all efforts have been exhausted to try and resolve the relationship, to try and mediate a solution where the parties can have some ongoing role. And it may just be that, for example, they need to arrive at an agreement which better and more clearly, for example, defines their roles and responsibilities within the company, or better and more clearly defines, for example, what sort of things are going to be drawn out of the company by way of directors' loan payments. That can often be a source of dispute. The other thing you need to sense check, and it's linked to this point really, I suppose, is there something really unfairly prejudicial about what has happened, or have they just fallen out? So you have to be wary of the client who is unhappy with the other shareholders, and they're likely other shareholders and directors, for personal reasons rather than for unfair prejudice reasons. It is, if you like, the other side of the coin I'm talking about just a moment ago, which is that just as you've got to be certain about the end game, or you've got to have an idea of what the end game is that your client wants to achieve, you've also got to be conscious of whether or not you're actually going to have any chance of getting there. The other thing that you've got to bear in mind is whether or not the client's valuation of the company is sensible. Now, the client is generally in a better position to understand or to make an estimate of the inherent value of the company than you are, and neither of you are likely to be experts. But you do have to ask yourself, what is the business of this company? Is it trading profitably? Does it have assets? Because companies may not be insolvent, but that doesn't necessarily mean that they are. The corollary of a company not being insolvent isn't that it is worth millions and millions of pounds. There's a vast range in between. And you need to have some understanding, or at least make some sort of assessment of whether or not this is a company whose value is likely to justify an unfair prejudice petition. If a company's profit is really at a very low level, the value of the shares is not necessarily likely to be very high unless there's some other special factor. And the costs of an unfair prejudice petition might quickly become disproportionate. So you have to be conscious of that risk, and you have to also bear it in mind in order to manage expectations. One of the biggest obstacles to settlement, I found traditionally, has been simply that petitioners have unrealistic expectations of what the company is worth. They are convinced that it is worth millions. They are convinced that they are not being told the full story. And of course, sometimes that's true, but a lot of the time it's wishful thinking on their part. And as a result, unless that is managed early on, you can end up in a situation where costs spiral out of control as a litigation rumbles onwards and onwards and onwards, with that expectation management not having occurred, and there therefore being this barrier to settlement because of a lack of realism as to what's likely to be achievable. And the best time to avoid all of that is to just ask the questions at the start, to just probe it. You don't have to reach firm conclusions. You don't have to give firm advice at that stage. You're probably not going to be in a position to do so. But you can at least start to say, well, if you're saying you think it's got all this value, how do we reconcile it with the fact that the accounts, for example, only show profit of X or Y, or we know that it's only assets of any real value is this bit of property and we think it's only worth Z. These are questions that it's useful to ask early on in the case. Now, on the other side of the dispute, if you're acting for the respondent shareholders, this is inherently difficult because the relationship between the parties has, in most cases, already probably descended to a level where they'd quite like to be rid of the petitioner. Indeed, it's not unheard of for respondents to have engineered circumstances to provoke petitions in order to get rid of the petitioner that they don't want. Now, in that scenario, the respondents are probably going to buy out the petitioner at some stage, as I discussed earlier. And once again, in smaller private companies, you can get into a situation where the costs involved in a petition will swiftly become disproportionate to the value of the company. The consequence of that is that a swift settlement is in many cases likely to be the cheapest deal available, because if there is a prospect that costs are going to escalate, your own costs are going to escalate, the other side's costs are escalating, and there's a prospect that you're going to end up paying those costs, the longer you hold off, the more expensive a deal may well become. The strongest tool in a respondent's bag, therefore, is what's known as an O'Neill and Phillips offer, coming out of the decision of the House of Lords and principally the speech of Lord Hoffman in O'Neill and Phillips. Now, what is an O'Neill and Phillips offer? It's an offer, an open offer, which can, in some circumstances, enable a respondent to secure summary dismissal of a petition. How does it work? Well, the idea is that you make this offer, and before you ever even have to then file points of response to an unfair prejudice petition, once the petition is launched against you, you can simply respond by saying, look, we have already made them an offer to buy them out, which is better than anything they're likely to achieve at the best they can do, even if they succeed in this petition. So actually, it can lead to the petition being struck out. But it's a difficult offer to make. Firstly, there are a number of principles that Lord Hoffman set out that the offer has to adhere to. I have, as you'll see in all of these slides, it will say emphasis added. The bits that I have highlighted in bold and underlined are the bits that I think are probably the most important. So the first thing is that the offer must be to purchase the shares at a fair value. And this is perhaps, with curious points, guidance says without a discount for its being a minority holding. Now, I'm going to come on to talk a bit about whether or not there needs to be a discount for minority holding in a moment. But certainly in the context of an O'Neill and Phillips offer, it would be very risky to make an offer for buyout that made it on the basis of there being a discount for minority holding and hope that that would provide you with the protection you were entitled to. I suspect that would only work in circumstances we'll see this later, where you can quite clearly point to the petitioner's shares originally having been acquired themselves at a minority discount to take account of the fact that it's only a minority holding. The second thing is that the offer should provide that the value, if not agreed, which is almost certain to be the case, should be determined by a competent expert. The offer in this case was made to appoint an accountant agreed by the parties, or in default of them agreeing an accountant, it was suggested that one would be nominated by the president of the Institute of Chartered Accountants. That works as a mechanism. So the offer has to contain a viable working mechanism in order to resolve the dispute as to what the value is. The third thing is that the offer should be to have the value determined by the expert as an expert. Now, what the House of Lords is focusing on there is the idea that you don't slip into having an arbitration, which itself can then engender further problems. What you're looking for is a clean cut where you say, well, we will buy you out. We will go to an expert. They will put a value on the shares. We will pay that. Done and dusted. The fourth principle is about equality of arms, and it is the idea that both parties should have the same right of access to information about the company, which bears upon the value of shares, and both should have the right to make submissions to the expert. So really what we're talking about there is the procedure for the expert determination. There needs to be an availability of information so that everybody knows what's being looked at and how you look at things. And there needs to be some sort of process for making submissions to the expert, for saying to the expert, we think you should take this or that into account. Now, critically, you don't need to come to any sort of agreement about what that procedure is going to be. I'm going to make written submissions in 14 days. You'll reply 28 days thereafter, or anything like that. It can be left to the expert to determine what he needs to hear and how he needs to hear it. But if you're going down that route, then there obviously is a benefit in trying to make sure you identify an expert who's got some appropriate expertise. The fifth thing is about when the offer should be made and whether it needs to also say, and we'll pay for your costs. And the House of Lords is clear that when you're making an O'Neill and Phillips offer, it doesn't always mean that you need to offer to pay costs. It really depends on when in the history of the dispute the offer is being made. So what Lord Hoffman said was that the majority shareholder should be given a reasonable opportunity to make an offer, which may include time to explore the question of how to raise finance before he becomes obliged to pay costs. Because in small companies, cost can be effectively your biggest risk, your biggest liability as the respondent might be facing. There is a real advantage to an O'Neill and Phillips offer because it enables you to actually say at the outset, we'll buy you out by going through this process, but you don't have to say, and we'll pay all your costs. So to some extent, it can shoot the petitioner's fox, because the petitioner will be well aware in most cases that the double or nothing element of costs is perhaps one of its strongest bargaining tools. So by being able to make an O'Neill and Phillips offer, which effectively is a way to settle the case, and to be able to make it valid without offering to pay any costs, is a really useful tool. But why are all unfair prejudice petitions not settled by O'Neill and Phillips offers? Well, one of the first things is that it can actually be difficult to formulate it if there is a dispute about whether money was legitimately extracted from the company, or if there are allegations of breach causing loss to the company. So simply put, if somebody's saying, well, you've taken money out, or you've redirected money to a company of your own, for example, breach of various fiduciary duties, and that needs to be pulled back into the company, notionally at least, in order for the purposes of valuation. How do you agree upon how do you formulate an offer that is acceptable for the purposes of O'Neill and Phillips, unless you concede that point? Because unless you're saying, yes, I agree, that we should value the company as at the point 2 years ago before various things happened, by way of example, there's still going to be a matter of dispute, which then means that, so if you're just saying, well, let's just value the company as it is now today in its current state, when you go to that first hearing, there's going to be a dispute about whether or not there are still matters that need to be resolved. And it may well be, therefore, that you're not going to get anywhere by trying to strike out a claim on the basis of an O'Neill and Phillips offer having been made, because the O'Neill and Phillips offer didn't actually represent the best outcome at trial that the petitioner could hope for. The other thing you've got to know, my point 2 and my point 3, that they're effectively, again, linked. So many things in law are two sides of the same coin. The offer's got to be an open one if you want to be able to rely upon it for summary dismissal, because you've got to be able to show it to the court. But as a result, it's not going to be a Part 36 offer. And if you say it's a Part 36 offer, under Part 36, it is imported into Part 36 that the offer is without prejudice, save as to cost. So if you want the benefits of Part 36, you probably need to be making two offers, one an open offer and the benefits of O'Neill and Phillips. You probably need to be making both an open offer and a Part 36 offer. And of course, the other main difference between an O'Neill and Phillips offer and a Part 36 offer is that it is implicit within a Part 36 offer that you're going to offer to pay the petitioner's reasonable costs to be assessed on a standard basis. Whereas, as I've just mentioned, in the O'Neill and Phillips offer, one of the major advantages of it is that it may enable you to get out of the litigation without paying costs. So they're different types of offer, and you just need to bear that in mind, depending on what sort of protection you think is most useful to you at the point in proceedings in which you find yourself. The next thing I'm going to talk about is valuing the shares. So the big question here, because I'm not going to get involved in the various merits of EBITDA and multipliers that so excite accountants, big question from a legal point of view usually is to discount the shares or not to discount the shares. And there is some contradictory authority here. The starting point in this tends to be Reay Precision Bellows Limited. There it was said that the shares will not be discounted for being a minority shareholding if it is a quasi-partnership, but will be discounted if they were originally acquired with a minority discount. So what happens in Reay Precision Bellows in the judgment is there are simply these 2 points given. So if it's a quasi-partnership, there won't be a minority discount. If the shares were originally acquired at a discount, then there will be a minority discount. There is quite a big gap between those two. And how it has then been understood has changed, oscillated in the case law. So in 2006, you have the court saying in Irvin and Urban that shares will be valued at a minority discount unless there is a quasi-partnership or some other good reason to attribute a pro rata value. So effectively there, the emphasis is placed upon the quasi-partnership element of Reay Precision Bellows rather than looking at the gap and seeing if there is anything within it. You then have two more recent cases, Re-Edwardian Group, where it was said that where the company is not a quasi-partnership, the court will apply a minority discount, but then add back in a marriage value. And what that is, it's a notional uplift to take account of the fact that in that case, what happened was when the minority shares were acquired by the respondent shareholders would have in excess of 75% of all the shares. And so they would have acquired a supermajority. The shares, therefore, and you can see this makes perfect sense, and a premium value for those buyers that they wouldn't have had from another buyer who was just going to have them be in a similar minority position. You also have in Reay Blue Index Limited a completely different analysis. And there it was said that the starting point was that there will be no minority discount unless the shares were bought at a minority discount originally. And Reay Blue Index Limited is interested, firstly, because the judgment was given by a deputy High Court judge who is very well familiar with the law in this area, writes one of the leading textbooks. But also, it's a very thorough judgment. It goes through and explains the pre-existing case law and how it should have been understood and how you interpret it in order to identify what was the ratio of those decisions. And it takes the thing through in quite a convincing way to get to this conclusion. However, as a matter of precedent, where you have conflicting High Court decisions, and indeed there are Court of Appeal decisions previously, Irving and Irving, those against the most recent High Court decision will take priority, and obviously the more senior court's decisions takes priority again. And so Blue Index Limited, whilst it is clearly in your interest if you are a petitioner, and a point that you would certainly want to pursue, I think there have got to be real questions about whether or not it's going to be binding at first instance on another High Court judge or not. My feeling is that it probably isn't, but that doesn't mean that the conclusion arrived at was necessarily wrong. Quasi-partnership, therefore, still retains quite a degree of importance, certainly from the point of view of pleading and tactical positioning. The starting point in relation to quasi-partnership is that in general, members have no legitimate expectation beyond the rights conferred in them by the constitution of a company. So they don't necessarily have any right to be involved in the management of a company. But they may have a legitimate expectation to be involved in the management of the company where there was a quasi-partnership. Now, the origins of this stem from a lot of corporate behaviour, effectively, that you would have seen 30, 40 years ago, and more recently, in fact, as well, certainly in the context one seen in solicitors' practices, where you would have had traditional partnerships, and then they would have incorporated. Now, that would have happened for lots of trading businesses back in the 80s, 90s. We've seen it more recently for lots of solicitor firms in the course of the last 2 decades, where traditional partnership models have moved towards limited liability companies in some situations. Obviously, limited liability partnerships were also popular. Quasi-partnership has two principal impacts on a petition. The first is that because it means that you might have a legitimate expectation to be involved in management, prima facie lawful exclusion from management, so for example, a majority using their shareholding to remove somebody from the board, may in and of itself be unfairly prejudicial. The second thing is that it may be relevant to whether a minority discount applies. So it still has a real impact. Now, when is something a quasi-partnership? The starting point is and remains the decision of the House of Lords in Ibrahimi and Westbourne Galleries from back in 1973. There, Lord Wilberforce said that it was firstly an association formed or continued on the basis of a personal relationship involving mutual confidence. Secondly, he said that there would be an agreement or understanding that all or some of the shareholders should participate in the conduct of the business. And third, a restriction upon the transfer of the member's interest in the company so that if confidence is lost or one member is removed from management, he cannot take his stake out and go elsewhere. It is not a hard and fast test, though. That is the important thing, and it has really escaped attempts by the courts to settle it down. So every time you get a case which purports to set out a test, you get another case saying, well, yes, that's applicable in that particular scenario, but it can't be applied universally. And so a lot of the time it is really a sort of put your finger in the air and see which way the wind is blowing. Does it look like a quasi-partnership? Does it feel like a quasi-partnership? What was the relationship between the parties? How did it operate? What was the history of the company? These are the things you've got to be looking at. The most common bar to a quasi-partnership arrangement, somewhat ironically, will be the existence of a shareholders' agreement. So, whilst it is in the essence of a quasi-partnership, there may be some sort of agreement or understanding as to their involvement, the idea that different people are going to have different roles, responsibilities, certain decisions might be taken by the group together, consensually or unanimously. If you actually go beyond that sort of loose understanding and you get to the stage where there is a formal document setting out, formal shareholders agreement setting out how things will be done, that agreement will often itself preclude the finding of a quasi-partnership, because the agreement demonstrates that the parties weren't relying on trust and confidence. What they were doing was they were setting out very clearly what their rights and responsibilities are. And if they want to enforce those rights and responsibilities, their cause of action is not unfair prejudice and a quasi-partnership. Their cause of action is to enforce the terms of the shareholders' agreement, at least in the first instance. Now, the other thing to bear in mind is that companies can start off as quasi-partnerships, but then lose that quality as they grow, or as the membership expands, or where the relationship is subsequently formalised in a shareholders' agreement. Finally, it's also possible for there to be a quasi-partnership between some shareholders but not others. This is, however, unusual, so it will arise and has arisen in Fisher & Cadman. It was recognised, but it's unusual because where you've got those other shareholders, well, actually, they have a legal right to see the company managed in accordance with the terms of the Articles and the Companies Act, those sorts of things, not in accordance with some sort of understanding as between two other shareholders, some sort of gentleman's agreement between them or what have you. So can arise, but it will be a rare situation in which it does. Finally, because we are running low on time now, I see, points of practice. First thing to bear in mind is that a Section 994 claim is commenced by petition rather than by claim form. If you look at the draft petition form, it looks like it's going to anticipate further points of claim because it appears fairly brief. But in fact, the common practice now is to draft a very long petition, because it will generally stand as the points of claim. At the first hearing, you would normally seek a direction to that effect. In a case where urgent interim relief is sought, it may be appropriate to present a shorter form of the petition and then seek a direction for further points of claim to be filed at a later date. You may simply not have time to draft a full petition. The company's unfair prejudice application proceedings rules, Rule 4, requires the petition be served on the company and other respondents not less than 14 days before the return day listed on presentation. But one of the things to bear in mind is that if you are issuing in London, Rolls Building will send out automatic directions now in response generally to a petition being presented, and it will direct that the petition be served within 14 days of, and it uses the word issue, but strictly speaking, petition is presented rather than issued. And it will also direct automatically for the petition to stand as points of claim, with a further direction then for points of defence and points of reply, and listing for case management afterwards, and most likely a direction also for cost management to take place. Finally, one of the things to bear in mind is that aside from the express variations in the 2009 rules, the CPR will apply. So you've got to be conscious of what is said in the 2009 rules, but you've also got to bear in mind that the general procedural rules of the CPR apply. Thank you all very much for attending. I see there are some questions asking if the slides are circulated. They will be. The recording of this, I believe, will also be circulated, and it will be posted on the Chamber's website, I anticipate, as well. You can follow King's Chambers and most of the barristers on it on Twitter and LinkedIn, so do feel free to do so. You will find there useful vignettes about cases and also advertisements for forthcoming talks that you may wish to attend. The next talk in our series will be from Nick Taylor, who's going to be dealing with the thorny issue of good faith in contracts. And in the new year, Chelsea Carter is going to be speaking about applications under sections 238 and 239 of the Insolvency Act 1986. So do make sure to sign up for those. They will both prove to be, I'm sure, very insightful and helpful talks. Thank you all very much for attending, and I hope you all have a very good day. Goodbye.